Welcome to Title IV-E training. The objectives for this training are to understand the importance of Title IV-E funding to the provision of services in child welfare, to have knowledge of the requirements for Title IV-E and how it is part of the normal casework process, and to be able to gather and document required IV-E information. So what is IV-E? The Title IV-E Act provides the largest federal funding stream for child welfare services. It covers the cost of room and board for foster care, subsidizes adoption of children with special needs, pays for training for child welfare staff and for foster and adoptive parents, and covers some of the child welfare agency's administrative cost. Title IV-E funds are available only to children whose family's income is low enough to meet certain federal income requirements. Title IV Part E allows grants to estates for aid and services to needy families with children and for child welfare services. In 1980, Congress passed Public Law 96-272, amending the Social Security Act of 1935 to provide federal funding for the placement of children. IV-E eligibility is still dependent on a child establishing need through the AFDC eligibility rules in place, July 1996. IV-E funding supports maintenance costs of foster care, adoption and subsidized legal guardianship, as well as the administrative and training costs supporting these programs. What this means is that for every dollar the state pays out for a child, the federal government will reimburse the state a portion of that cost. The federal government has little to no restrictions on what a state can do with the funds. There's currently no cap on the amount of money that can be reimbursed if children are eligible. However, the amount we are currently being reimbursed is based on our penetration rate, or P rate, as some may hear it called. The Administration for Children and Families is the federal agency that sets regulations and monitors the Title IV-E foster care and adoption assistance programs. Why is this so important? Collection of the federal reimbursement for expenses paid out by DHHR is important to the children and families we serve. Without this money, our ability to provide the level of service they deserve is diminished. Think for a moment about how IV-E affects you. 75% of your salary is reimbursed to the state via IV-E while you are in pre-service training. This reimbursement helps with the budget and can be used for staff raises, equipment, new offices, and so on. Let's talk some more about what the reimbursement is for and what we can do with it. DHHR is reimbursed for up to 75% of the cost of eligible children in foster care, although some categories are only reimbursed at 50% of cost. Pre-service training is reimbursed at a rate of 75% of the cost for the entire time the worker is in pre-service and does not carry a caseload. During the pre-service training period, workers cannot have a primary case assignment on their workload. If a worker is assigned a caseload, then pre-service training is not reimbursed at the 75% rate, but at a lower rate. In-service and ongoing training is also reimbursed, but only at a rate of up to 50%. Administrative costs are reimbursed up to 50%. That is why we do ROSA. Time study is a key component in determining reimbursable administrative cost. IV-E provided funding for SAC-WIS system, that's State's Automated Child Welfare Information System, development and implementation. That is how we got FACS. Everyone get ready for a math problem. The $82,125 is just the cost associated with out-of-home care. This does not include the worker's salary or the administrative costs associated with this child, so the actual amount could be much higher. The most important thing to remember is that this reimbursement helps us to provide the best possible services to the children and families that we serve, and also pays the salaries of all our child welfare positions. When the penetration, or P rate, is low, and we are not bringing in those federal reimbursements, the state alone has difficulty covering those costs, and cuts to programs and positions are often made. In the past, federal money has been used for staff raises, not IV-E but TANF money. As a worker, you need to understand what makes a child eligible for Title IV-E. So now we are going to discuss the requirements or guidelines that have to be met. Later, we will go over the required documentation and facts. If we looked at a puzzle, it would be complete as long as all the pieces were in place. As soon as a piece is removed or separated, the puzzle is no longer complete, no longer a picture. Eligibility for IV-E consists of 4 pieces: removal, court-ordered language, financial need, and deprivation. In order for a child to be deemed eligible for 4E reimbursement, all 4 pieces must be complete. Things you do in your day-to-day casework affects Title 4E eligibility. Documentation of certain information is the key to determining a child's eligibility. We're going to cover all those requirements. Though the determination itself is automated, the worker is still required to input the data into facts that will initiate the determination for the child. The 4E specialist also plays a role in verifying that data entered is accurate. To claim Title 4E reimbursement for a child or youth in out-of-home care, the eligibility must be established and maintained. Remember, the establishment of 4E means that the worker collects and enters the necessary data for a determination to be done. A very important practice note: updating client information is part of the case planning process for providing updates to the court and such, even if it is not required for 4E. When updating information for your case plan, for example, make sure to end-date current information if applicable and create a new line to document new information. Changing existing data can result in a change in the child's determination. The education page in facts plays an important role in determining eligibility beyond the age of 18. The education page in facts will be discussed later during the required documentation part of this session, as the estimated date of completion date field is important to 4E. Only children have to be U.S. citizens for 4E eligibility. The parent's status will not affect the child's eligibility. In facts, the system automatically defaults to U.S. citizen for all clients. These are the 8 areas that need to occur for eligibility. Correct language in court orders is one of the biggest challenges we face. If the language is not contained in the initial order that removed the child from their home, then the child will never be eligible for 4E during this removal period. That is a great expense to the state, especially if the child remains in care for an extended period of time. Remember, you as a taxpayer in West Virginia are taking on the burden of this expense. As a worker, you have a role in what is put into the court order. Let's review the specific language that court orders need to contain. Contrary to the welfare, this eligibility criterion applies to court orders placing the child or youth in care. It indicates that the safety of the child could not be maintained in the home. This must be contained in the removal order, which is the order that granted the DHHR temporary custody of the child and ordered removal from the home, giving DHHR care, control, and placement responsibility. Without this in the order, the child will not be eligible for 4E reimbursement. Reasonable efforts to prevent removal. What was done to prevent removal from the home? The petition should have listed all reasonable efforts that were made or not made to prevent removal. These statements must also be in a removal court order within 60 days of DHHR custody. Reasonable efforts to achieve permanency. This is the same as reasonable efforts to prevent removal, except the worker should petition the court for a permanent placement review hearing in the 11th month of the removal, and the hearing must be held in the 12th month, and the resulting court order must state reasonable efforts to achieve permanency. This is achieved either by reunification with parents or adoption, and the order should explain why it has not been done within 12 months. There also must be a plan to achieve permanency, citing any possible barriers to that permanency plan. Details are contained in all foster care policy. If this is not done in the 13th month that the child is in placement, the child will become ineligible for 4E. Workers may want to ask for a REAP statement in all applicable orders where the issue is addressed. If the court order contains the correct language, then the next criteria is removal. Was the child removed from their normal place of residence and ordered into DHHR legal and physical custody? If this criterion is met, then we look at specified relative. A specified relative is defined as a blood relative. Those of half-blood, brothers or sisters, grandparents, great-grandparents, great-great-grandparents, great-great-great-grandparents, uncles or aunts, great-uncles or aunts, great-great-uncles or aunts, nephews or nieces, first cousins once removed, or adult siblings. Specified relatives are also step relationships, legal step-parent, step-brother or step-sister. Spouses of step-parents are not specified relatives. Legal spouses. If any person named in any of the above groups except for spouses of step-relatives, the specified relationship exists even though the marriage terminated in death or divorce. Legal custody or guardianship of a child does not in itself qualify a person as a specified relative. natural or adoptive parents. Adoption procedures must be finalized in order for an adoptive parent to qualify as a specified relative. If a child is living with his natural father and paternity has been legally established, the father is considered a specified relative. A relative of the father of a child born out of wedlock can qualify as a specified relative only if the child's paternity has been established. When an adoption is finalized, the ties between the natural parent or parents and the child are severed. The natural parents do not retain a specified relationship as a parent. When parental rights have been severed, but no adoption has been finalized, the parent is no longer a specified relative, but all other relationships of the child are unaffected. The child or youth must have lived with and been removed from a parent or other specified relative at some time within the 6 months or 180 days prior to removal in order to be Title IV-E eligible. This does not mean that the child or youth had to be living with a specified relative at the time of removal, just that there has been some period within the last 180 days during which the child or youth did live with a specified relative that they are removed from. In cases where juveniles have been running the streets, if a parent or relative has been maintaining the home and having some contact with the youth is considered to have been living with that person. This topic becomes important in the completion of the removal screen and the relationship screen in facts. Workers must be diligent about the accuracy of the relationships they are entering. If a person is a step-parent, they must be identified as such, a half-sibling, so on and so on. If this criteria is met, then the placement of the child is considered. The placement of the child must be with a certified provider. Kinship relative placement. The child may meet the other criteria for 4E eligibility, but while placed with the kinship relative, they will be considered eligible but not reimbursable. Remember, though, that kinship relatives are encouraged to become certified foster care providers. This will make the child 4E eligible. It also provides the relative with monthly boarding care. If a child is placed out of state, they may be 4E eligible, but if the placement is not WV-DHHR certified approved, West Virginia cannot recoup the cost of care. If a child has the proper court-ordered language, was removed from their own home, lived with a specified relative, and is placed in a certified foster home, are they 4E eligible? Almost. Now we have to see if there is a deprivation factor. Consider the following questions. At the time of removal, was the child deprived of the care of one or both parents? At the time of removal, was the child deprived of care due to incapacity of the parent? At the time of removal, was the parent the child resided with unemployed? If the youth is living with only one parent because of death, divorce, separation, or desertion, deprivation exists. If the youth is living with someone other than a parent, then deprivation exists because there is continued absence of both parents. In this case, deprivation will continue to exist unless both parents move into the home in which the youth is living. This is why it is so important to locate absent and unknown parents. If the person remains absent from the child's home, that is an established deprivation factor. Consider incapacity. Evidence that a parent receives SSI or SSA disability is enough to establish incapacity. Other methods may be more difficult, but possible. An example. A psychological evaluation states that the parent has a condition that makes it unlikely that they can adequately care for a young person. You may be able to obtain a statement from the psychologist with the parent's consent. Other indicators of incapacity may be workers' compensation or veterans' disability benefits. Let's consider unemployment. Records showing that one or both parents the child resided with were unemployed at the time of removal established deprivation. Finally, the death of one or both parents being deceased at the time the child or youth is removed from the home establishes deprivation. So, if we have established court-ordered language, a removal from the home, placement in a certified foster home, and a deprivation factor, is the child 4E eligible? Almost. Now we need to know if there is a financial need. Can the DHHR be reimbursed for the cost of care by other means, such as child support? At the time of removal, we must collect the income, asset, and debt information from one or both parents. Income is defined as money coming into a household on a regular basis. Earned income is a salary, wages, or income from a private business. Unearned income is payments from Social Security, child support, VA benefits, or any other such payment not immediately associated with work performed. The family's income cannot exceed the consolidated needs standard. Assets are money or possessions that can be readily turned into cash. Debts are money that is owed. Certain parent debts will be deducted as part of the countable income. These typically would be alimony payments, child support for a child not in this household, dependent care, and insurance premiums that are paid to someone outside of the home or are not part of this benefit group. Some other debts may be pertinent for case planning but are not counted for 4E. It is very important to capture these parental debts, as failure to do so could mean a parent appears to be over income for 4E eligibility. So if all these pieces fall into place, a child will be eligible for Title 4E reimbursement. Remember that we live in West Virginia, and most families in this state live below the poverty level, so most children we take into care should be eligible if all the criteria are met. Take a moment and consider the following points. As workers, where do you see the biggest barrier in meeting this criteria? What can you do about it? Thinking of the children on your workloads now, how many would meet this criteria? If not, why? What can you do about it? Let's practice. The DeGrady Bunch. Carol and Mike are married. Carol has 3 golden-haired girls from a prior marriage, and Mike has 3 mop-top boys from a prior marriage. Later, it is discovered that Mike, Carol, and their housekeeper Alice are selling meth out of the house. The kids all run away after a violent episode at home and are brought into care. Let's go down our list of 8 and assume first that our court order contained the proper language. Removal. Were the children removed from their normal place of residence? Yes. Specified relative. Did the children live with a specified relative? Yes. Placement. Are the children placed with certified approved providers? Yes. Is there deprivation? This requires some thinking. Yes, all the girls are missing their biological dad, and all the boys are missing their biological mom. Marriage between step-parents does not eliminate deprivation. Is there a financial need? Depending on Carol's income and work history, the girls should be eligible for 4E. Depending on Mike's income and work history, the boys should be eligible for 4E. The Simpsons. The household consists of 6 people, 3 adults, Marge, Homer, and Otto, and 3 children, Bart, Lisa, and Maggie. Marge is the mother of all 3 kids. Homer is the father of Bart, Otto is the father of Lisa, and Mr. Burns is the father of Maggie, but no one has seen Mr. Burns in years. Marge is not married to either of the men in the home. Homer works as a greeter at Walmart, full-time at minimum wage. Otto used to be a vacuum cleaner salesman, but he was fired, and now he and Marge lie around doing drugs and other worthless activities. After a big family fight resulting in arrest, the kids come into care. All 3 children are placed with Marge's sisters, Patty and Selma. Are any of the children eligible for 4E? Do we have the proper court-ordered language in the removal order? Let's assume yes. If no, then the children will never be eligible. Were the children removed from their normal place of residence? Yes. Did they live with a specified relative at the time of removal? Yes. Are they placed in certified approved placements? No. They are kinship relative placement. Let's assume Patty and Selma have agreed to go through foster parent training, so let's keep going with our determination. Note, we still claim administrative cost when children are in relative placement. Is there deprivation and financial need? We have to look at each child individually. Bart. No. Because both parents are in the home, Homer works full-time, and there is no indication of another deprivation factor. Drug abuse is not a disability or incapacity. Lisa. Yes. Otto is unemployed at the time of removal. Maggie. Yes, because her father is not in the home. Marge does not work. Deprivation can still exist with multiple adults in a household. It is important to look at each child individually. Some have different deprivation factors, absent fathers, etc. For this scenario, what would be one of the most important screens and facts to complete? The relationship screen identify all member relationships correctly to each other. To review, a safety determination is made and a child is removed from their home. You, as the assigned worker, complete all required documentation and facts. Upon completion of the removal screen, the 4E unit receives an automatic secondary assignment to your case. You will see this under the Assign page. The 4E specialist will review the information and verify that the language in the court orders meets the requirements. They will also attempt to verify any employment, income information using RAPIDS and/or OSCR resources. The 4E specialist will run the initial determination for 4E eligibility. The 4E specialist will contact the assigned worker regarding the need to scan in the court order at the 12-month point. The 4E specialist will verify that order contains REAP language, that's reasonable efforts to achieve permanency. The 4E specialist will run a 4E redetermination. Now that we have covered why 4E is important and what makes children and youth eligible, let's discuss documentation. The worker is responsible for the collection of information that is necessary for FACS to perform the automated 4E determination. While the 4E specialist can assist the worker in obtaining some information, their primary role is to verify court order language and 4E documentation that is entered into the case. When a child is removed from their home and placed, the 4E specialist receives a secondary assignment to the case in FACS. It is not up to the worker to determine if a child is or is not eligible for 4E. Workers must collect and enter the data for the determination. Data for 4E is collected from a variety of different screens in FACS. In the resources area of this course, you will find a 4E desk guide. Please refer to the 4E desk guide in the reference section of this course for further definitions and a detailed step-by-step process on completion of these screens. All clients must be entered into the record. Each child must have 2 parents, and relationships must be defined correctly on the relationship screen. Deceased parents are also entered. For unknown parents, enter the first name as unknown and the last name as unknown. If there are multiple children in the household that have an unknown parent, document as unknown unknown child's name, example, first name, unknown last name, unknown Susie. This allows you to correctly link the parent-child on the relationship screen. In addition to FACS documentation, court orders play a vital role in 4E eligibility. A removal order is the court order that grants the department care, control, and placement responsibility of a child. In West Virginia, this most often occurs when a petition is filed alleging abuse or neglect, or a status offense or delinquency, and a subsequent order is issued. If a child is removed in an imminent danger situation, and the worker utilized the magistrate court system to file ratification for emergency custody that does not grant the department temporary custody, ratification simply approves the action the worker has taken, often with approval from the judge. This is documented in FACS as worker protective custody. Since the ratification does remove the child from their home, it is considered the removal order and must contain all the necessary language for 4E eligibility. Keeping in mind that ratifications are used only if present danger or imminent danger exist and cannot be controlled, then the language in the ratification in regard to reasonable efforts would be child was in imminent danger and/or contrary to the welfare. Ratification should be the exception, not the rule. Be careful not to confuse the emergency filing of an actual petition that will likely result in temporary custody with the ratification process. Worker protective custody means that the worker witnessed the imminent danger or has reason to believe the child will be in danger, and they remove the child without custody and go straight to the magistrate or judge to file a ratification for emergency custody. In a sense, this is no different than law enforcement taking custody. Often there is a struggle with how to obtain the required information. The family itself can assist in obtaining information that is required for 4E, in addition to providing information to meet other foster care requirements. Refer to your previous foster care or children in care training and all the requirements that have to be completed when a child is placed. Families can assist with dates of birth and social security numbers. They also may be able to provide copies of these documents. Remember, these are part of the Journey Placement Notebook. Families can provide information on household composition information to assist in the completion of the relationship screen. They can provide educational information on the child, financial information, employment, and unemployment information. One of the best times to request some of this information is at the first MDT. Besides the FACS system, West Virginia DHHR has other databases that can assist in collecting needed information. RAPIDS, Recipient Automated Payment Information Data System, OSCR, Online Support Collections and Recording, IPACT, Interstate Paternity Acknowledgement Certification Transmission, and DMV, Department of Motor Vehicles. IPACT is a system developed by the Bureau for Child Support Enforcement as a way to view or order birth and/or death certificates. All child welfare workers are given access to iPact. Logon and resets are managed by the Fax Help Desk for child welfare staff. With all of this information, let's discuss some of the most common errors in reporting and how to prevent them. Some of the most common reasons a child is determined ineligible for 4E funding are that the child has no deprivation factor, the removal order either does not contain the correct language, or has not been obtained, or the family is over income. Children can receive both SSI and 4E. They can be eligible for both, however the amount of SSI is deducted from the 4E claim. Sometimes a court will order a child removed from one parent and placed with the other parent. This does not constitute a removal, and the removal screen and fax should not be completed. It is extremely important to follow in the approval of relatives as placements. Workers must work with their home finders to get the relative entered in fax as a kinship relative provider within the required 3 working days, so a link can be made in the placement area of fax. After the relative's home study is completed and approved, the home finder documents that information in fax. The home finder then contacts the child's worker to inform them that the relative is now opened as a certified foster care provider. The assigned worker dates the kinship relative placement and places the child with the certified foster care provider, same person. In addition to making the child 4E eligible, if there are no other barriers, this will also provide the relative with monthly boarding care payment of $600, a medical card, and school clothing allowance for each child placed in the home. For example, if 3 children are placed with grandma, monthly boarding care equals $1,800, school clothing allowance of $750, and medical coverage, priceless. The kinship relative screening tool must be completed on all placements by the worker making the placement, regardless of the length of stay. This information must be forwarded to the home finding unit within 1 day of placement. The worker must provide the kinship relative placement an explanation of all benefits they are entitled to, including TANF, Medicaid, etc. Relatives have the option to seek custody in family court prior to our involvement. Circuit courts can also transfer custody from DHHR to a relative if that is in the best interest of a child. If a child is ordered into DHHR custody, but not placed in foster care, as sometimes happens in truancy or youth services cases, this does not constitute a removal. Do not complete the removal screen in fax. Sometimes there are youth who are in the custody of the Department of Juvenile Services who transfer into the custody of DHHR. In these cases, workers must enter the removal date in fax starting the day that DHHR obtains custody and placement responsibility of the child. You also show that the child was removed from their caretaker, not the Department of Juvenile Services. DHHR needs copies of all DJS court orders. Anytime assistance is needed with 4E cases, there is help available. A 4E specialist is assigned to each county, although there may not be a person housed in each district office. Child welfare consultants should be one of your first stops for information and questions regarding policy and requirements. Child welfare trainers and program managers can assist staff with documentation of information and can answer questions regarding policy and requirements. And always remember to contact the Fax Help Desk with questions pertaining to the fax application.